So, imagine for a second having the blueprint to bust open one of the most notorious, just universally condemned criminal rings in modern history.
Right, if you have the exact map.
Exactly. You know where the crimes happened. You have this massive state-level investigative apparatus ready to go, and you are actively hunting for co-conspirators who have, evaded justice for years.
They've been completely off the hook.
Yeah. But the only thing standing in your way, the actual entity actively blocking the door, isn't the criminal syndicate itself.
Which is what you'd expect.
Right. But no, it's the United States Department of Justice.
Wow.
I mean, today, the state of New Mexico is literally suing the federal government because the DOJ just refuses to hand over unredacted files related to Jeffrey Epstein. So, welcome to the deep dive.
Thanks for having me.
We have a really fascinating mission today. We are going to explore this high-stakes legal showdown that is basically functioning as a massive stress test for the American justice system.
It truly is a remarkable collision of state sovereignty and federal authority. I mean, it is playing out right now in real time.
Yeah.
And what we are looking at isn't just, some minor bureaucratic spat. It is a fundamental breakdown of the cooperative trust that law enforcement actually relies on every single day.
Exactly. And the source material we are drawing from to really understand this breakdown is a highly detailed video report and transcript by legal commentator Katie Fang.
She's got great insight on this.
She really does. She was actually on the press call with the key players in New Mexico, and she breaks down the nuts and bolts of this brand new lawsuit. But before we get into the heavy legal machinery here, we definitely need to set some parameters for you, the listener.
Right. That is critical. I mean, our source material today is extremely detailed, but it also contains some pretty strong political opinions and, explicit critiques of the current Trump Department of Justice.
Yeah, we have to acknowledge that.
Definitely. But, as always, our ground rules remain the exact same. We are not here to endorse any political viewpoint or, pick a side.
We're staying right in the middle.
Precisely. We are going to serve strictly as your impartial guides through this document. We're just going to analyze the facts, the historical context, and the actual specific legal claims presented in the report.
So you can understand exactly how this machinery works and why this conflict is escalating all the way to a federal court.
Right.
Okay, let's unpack this. The core conflict really centers on New Mexico Attorney General Raul Torres.
He's the one leading the charge.
He is. His office has just filed a massive 40-page federal lawsuit against the DOJ, specifically naming acting U.S. Attorney General Todd Blanche.
A 40-page lawsuit is no small thing.
No, it's huge. New Mexico is basically claiming the federal government is actively stonewalling their ongoing criminal investigation into the Epstein network. And, this frustration didn't just happen overnight.
This has been building for a while.
Yeah, it's been a very slow, very tense boil. According to the report, Attorney General Torres has been asking the federal government for these unredacted Epstein files for 173 days.
I mean, in the lifespan of an active criminal investigation, 173 days of waiting for vital documents is an absolute eternity.
Right, because things go stale.
Exactly.
Well.
Cases go cold, witnesses disappear, statutes of limitations tick down. It is a massive roadblock.
And they didn't just ask once and then, sit by the mailbox waiting.
They were persistent.
Very. New Mexico has made 10 separate formal requests, and this spans across 2 different acting U.S. Attorneys General.
So this is an institutional problem.
Yeah, they started asking when Pam Bondi was in the role, and they just continued asking under Todd Blanche. 10 attempts to get full, unredacted access to case files concerning crimes that happened on their own New Mexico soil.
And we should probably look at what they actually got in return for all that.
Yeah, so what did they actually get in return for a half year of pleading?
That is the metric that really illustrates the tension here, honestly.
Right. There must be millions of pages of evidence the federal government has amassed on this criminal enterprise over the years.
Oh, easily millions.
Well, New Mexico has received exactly 31 pages of document.
31 pages, wow.
Torres actually went on the record calling it a paltry disclosure. And New Mexico is arguing this isn't just, bad manners or bureaucratic sluggishness.
No, they are claiming this stonewalling unlawfully interferes with the state's sovereign authority to investigate and prosecute crimes.
Which sounds incredibly heavy. But I want to break that down for a second. If you request the blueprint to a skyscraper and someone hands you a single Post-it note with a doodle of a window, you're going to feel stonewalled.
That's a great way to put it. You can't build a case with a doodle.
Exactly. But why is state sovereign authority such a big deal in a case like this? I mean, the feds already went after Epstein, right? They prosecuted Ghislaine Maxwell. Hasn't the federal government already basically handled this at the macro level?
What's fascinating here is the mechanics of dual sovereignty in the American legal system.
Okay, break that down for me.
Well, we often think of the justice system as one giant hierarchical umbrella,
You're
right? Where the federal government sits at the very top and state authorities are just sort of lower-level employees.
Yeah, that's how it looks on TV.
Right. But it's actually two completely separate, overlapping systems. Under the Constitution, states have a fundamental sovereign right to police their own territory.
So they don't answer to the feds in that regard.
Exactly. It absolutely does not matter if the federal government has investigated, prosecuted, or even closed a federal case on a target.
Really? Even a massive one like this?
Yes. If a state law was broken in New Mexico has the ultimate constitutional authority and, honestly, the duty to investigate it.
You know, it makes me think of two separate security systems monitoring the exact same building.
Okay, I like where this is going.
Like the federal government owns the cameras in the lobby, and the state government owns the cameras in the vault. If a massive crime happens inside the vault, the state needs the lobby footage to see who walked in and out.
Right. They have to have it to see the full picture.
Exactly. So if the feds say, well, we already handled the lobby investigation, so you don't need the tape, that completely breaks the structural design of how these two systems are supposed to work together to secure the whole building.
That is an excellent way to visualize it. A federal prosecution does not preempt a state's right to seek justice for state-level crimes committed in its own jurisdiction.
It just doesn't.
No. So New Mexico is asserting that by withholding evidence gathered about crimes on New Mexico soil, the DOJ is effectively crippling the state's constitutional policing power.
They are holding back the lobby footage, to use that analogy.
Exactly, making it impossible for the state to do its job in the vault.
And New Mexico specifically needs this footage right now because they aren't just looking to write some historical record of what happened. They are looking for actual actionable evidence.
Because they have an active case.
Yes. Based on our source, New Mexico is currently running the only open criminal investigation in the United States into Epstein and his co-conspirators.
You really have to let that sink in for a second.
It's wild.
Out of 50 states and the entire federal apparatus, New Mexico is the only jurisdiction with an active, ongoing criminal probe into this universally condemned network.
And their focus is highly specific. They are zeroing in on a property called Zorro Ranch.
Right, out in New Mexico.
Yeah, it's this massive estate located just outside of Santa Fe. And the Attorney General notes that Zorro Ranch is referenced over 13,000 times in the publicly available, heavily redacted Epstein files.
13,000 mentions.
13,000. I mean, they know this ranch was a central geographic hub in this criminal web.
Absolutely.
They believe that unredacted files will reveal potential victims who were trafficked there, maybe corroborating witnesses who saw what happened, and critically, co-conspirators who might still be out there living their normal lives.
Exactly. I mean, they are looking for the names behind those thick black highlighter marks.
They need the raw data.
They do. They are looking for the financial records, the flight logs, the specific testimonies that actually tie individuals to state-level crimes committed at that specific ranch.
Now, parallel to this criminal probe, there is another very interesting dynamic playing out within New Mexico itself.
Right, the legislative side.
Yeah, the state legislature passed bipartisan legislation to create an Epstein Truth Commission.
Which is a huge deal on its own.
It is. This commission has been doing its own investigation, looking into the history of the ranch, and coincidentally, they released their interim report on the exact same day AG Torres announced his lawsuit against the DOJ.
So you literally have two separate state entities, both looking into the exact same massive scandal running on parallel tracks.
But they are emphatically not sharing notes.
No, not at all.
During the press call highlighted in the report, a reporter asked AG Torres if he was working in tandem with this Truth Commission, and Torres basically said absolutely not.
He was very clear about that.
Yeah, he stated that because his office is running an active criminal investigation, he cannot share what they are finding with the Truth Commission. He said he has to protect the integrity of his case.
Which makes sense from a prosecutorial standpoint.
But honestly, I have to push back on this a little bit. Wait, if New Mexico is so incredibly upset about the federal government not sharing information with them, isn't it a bit hypocritical that AG Torres won't share his own findings with his state's Truth Commission?
It's a fair question.
I mean, he's suing the feds for stonewalling while actively putting up a wall in his own backyard.
It is a completely fair challenge, and I agree it certainly looks like a contradiction on the surface.
Right.
But if we look closely at the mechanics of law enforcement and government inquiries, there is a very critical structural difference between a legislative truth commission and an active criminal investigation.
Okay, tell me how they differ.
Well, a truth commission's mission is fundamentally backward-looking. They exist to audit systemic failures, to publish comprehensive public reports, and to recommend changes to legislation so, these tragedies just don't happen again.
So their whole goal is exposure.
Exactly. Their entire power lies in public disclosure and transparency.
Right. They want everything out in the open so the public can see exactly where the system broke down.
Exactly. But a criminal investigation is strictly forward-looking, aiming towards securing indictments and holding trials.
Which requires keeping things quiet.
Yes. For a criminal probe to actually succeed, it requires absolute secrecy, especially in the grand jury phase.
Oh, right. Grand juries are completely sealed.
They have to be. If an attorney general shares early findings, suspect names, or witness statements with a public commission, it could tip off targets who might flee, allow physical evidence to be destroyed, or irreversibly taint a future jury pool.
That would ruin the whole case.
It would. The two tracks are running parallel. But by their very legal nature, they inherently cannot cross. Torres has to guard his case file just as fiercely as the federal government guards theirs, because premature disclosure kills criminal cases.
Oh, okay, I see. The mechanics of that make total sense. Transparency is the goal of the commission, but secrecy is the primary tool of the prosecutor.
Exactly.
So, if New Mexico has a valid, constitutionally protected criminal probe that relies on secure information sharing, why wouldn't the federal government just hand over the files confidentially?
You'd think they would.
Right. State and federal law enforcement agencies share highly sensitive intel every single day without blasting it to the public.
All the time.
To understand this specific standoff, the source points us to some serious historical friction between New Mexico and the DOJ.
Yeah, this relationship didn't just fracture over these recent 173 days.
It goes way deeper than that.
It really does. There's a deep-seated institutional history of mistrust between these two specific bodies regarding this exact case.
Let's go back to 2019. According to the lawsuit, New Mexico's previous attorney general was actively investigating Epstein and the Zorro Ranch.
They were already on it.
But they were explicitly told by federal authorities, specifically the Southern District of New York, who were handling the massive federal case, to stand down.
In law enforcement circles, telling a sovereign state agency to stand down is a massive request.
I can imagine. It sounds pretty bold.
It essentially means halt your state-level work, give us the right of way, and let us handle this globally. It relies heavily on professional courtesy and reciprocal trust.
And New Mexico claims that trust was entirely broken.
Completely shattered.
The state was asked to discontinue their active investigation and hand over all of their gathered materials to the federal prosecutors. And the feds allegedly promised that if anything popped up in their massive federal dragnet that was relevant to state crimes in New Mexico, they would share it back.
Which is a standard promise in these situations.
But according to New Mexico, they never got their original materials back, and the feds never proactively shared the relevant information as promised.
They just kept it all.
Yeah. The source also notes that the U.S. Attorney for the Southern District at that time was Jay Clayton, who is now the Director of National Intelligence.
Right, a very prominent figure.
He was the one who allegedly refused to help New Mexico get access back then.
So from New Mexico's perspective, they played entirely by the rules in 2019.
They did what they were supposed to do.
Right. They yielded to the federal prosecution as a professional courtesy, handed over their hard work, and were essentially ghosted once the federal case concluded.
Just left unread.
Basically. That historical context is crucial for understanding why they are filing a 40-page lawsuit today instead of just writing another polite letter.
But the DOJ does have a stated official legal defense for why they are withholding these files today.
They aren't just doing it for no reason.
Right. They aren't just ignoring New Mexico out of spite. They are pointing to very specific legal constraints. The DOJ claims that releasing the unredacted files to New Mexico would violate the Epstein Files Transparency Act, and more importantly, it would violate federal protective orders put in place by judges.
And those are serious.
Yeah. These orders are specifically designed to shield the private identifying information of the victims.
And that is a very powerful defense. Protective orders are not just suggestions or, bureaucratic guidelines.
They have teeth.
They are strict judicial mandates. If an agency violates a protective order, they can be held in contempt of court.
Here's where it gets really interesting, though. Isn't the DOJ in an impossible legal bind here?
How do you mean?
Well, if they hand over unredacted files to a state agency and a victim's identity leaks, the feds get sued for violating a protective order. But if they don't hand them over, they get sued by New Mexico for obstruction. Are they just using victim privacy as a convenient shield, like New Mexico claims? Or is it a legitimate legal trap that any attorney general would have to navigate?
It requires looking at the mechanics of how these orders actually work in practice.
Okay, let's look at that.
Yes, a federal protective order is a strict boundary, and the federal government has an absolute duty to ensure that unredacted files don't become public.
Obviously.
However, weighing against that is the historical norm of law enforcement cooperation. This is not some unsolvable puzzle.
So how do they normally solve it when a state needs federally protected evidence?
They file a joint motion.
Or a joint motion.
Yeah. It is incredibly common for federal and state authorities to go together to the federal judge who issued the protective order. They file a motion asking to amend the order, specifically to allow state law enforcement to view the evidence confidentially under the exact same strict penalties for leaking.
Oh, so they just ask the judge for permission to share it securely.
Exactly. The judge reviews it, agrees that state law enforcement has a legitimate investigative need, and amends the order.
It's that simple.
Usually, yes.
Yeah.
The fact that the DOJ has allegedly refused to even ask a judge for that modification is what makes New Mexico highly suspicious.
And the source material pushes back hard on the DOJ's defense by pointing out a massive compromise New Mexico offered.
Right. They didn't just demand a flash drive.
No, they didn't just demand the files be emailed to them. New Mexico offered to send a team of state investigators directly to Washington, D.C. to view the files in a secure room at Main Justice.
Which addresses all the security concerns.
Right. No internet transmission, no physical copies leaving the building, just eyes on the files in a federally controlled environment. And acting AG Todd Blanche allegedly refused that offer completely.
Which is highly unusual.
Very.
Rejecting a secure room review at Main Justice makes the DOJ's stance look less like a strict legal bind and more like an active, intentional blockade.
Yeah, it looks bad.
They appear to be rejecting standard everyday solutions that would perfectly protect both victim privacy and honor state sovereignty.
And the source also alleges that the DOJ has a very spotty record when it comes to actually protecting these victims in the first place, which really undercuts their whole argument.
Right, there's history there too.
The report claims the DOJ previously leaked detailed, unredacted personal information about survivors themselves, ranging from contact details to highly sensitive images, and never fully secured the breach.
That's a massive failure.
And it gets worse. The report also claims that during a recent meeting with victims, Todd Blanche was outright dismissive, allegedly telling them to hurry up and get to the point.
Ouch.
So New Mexico is basically saying, you don't get to play the privacy card now when you've been careless with these victims in the past.
It certainly fuels the argument that the DOJ's sudden, fierce commitment to the letter of the protective order might be pretextual, rather than, a genuine concern for the victims.
So diplomatic options are completely exhausted. The historical trust is totally gone. The feds won't even let them into a secure room.
They're completely shut out.
If you're a state AG facing a locked federal vault, you can't just keep knocking. You have to legally force the door open.
Right.
And they're trying to do that with a highly specific legal arsenal.
And this is where we get into the intricate machinery of federal administrative litigation.
Which is complicated.
Extremely. Suing the federal government is incredibly difficult. You need a very specific key to open that door.
Well, New Mexico filed their 40-page lawsuit in federal district court in Washington, D.C. And the entire lawsuit hinges on something called the Administrative Procedure Act, or the APA.
Yes, the APA.
There are two main counts here. Count 1 alleges that the DOJ denied something called a TUDY request from New Mexico.
A very specific kind of request.
Right. The lawsuit claims this denial was arbitrary and capricious because it lacked any basis in the DOJ's own regulations.
Okay, that's count 1.
And count 2 alleges that by unlawfully withholding these documents and unreasonably delaying action, the DOJ is breaking down the critical trust relationships between state and federal law enforcement.
These are very specific, highly technical administrative law mechanisms that require a massive burden of proof.
So they are citing a Tuffy request. Now, I know this isn't just a standard Freedom of Information Act request where any citizen can ask for documents.
Right, it's not FOIA.
This is a specific legal channel for litigation, right? So what does this all mean? What exactly is a Tuffy request? Is that just a fancy legal version of a FOIA request, or is it something different? How does the DOJ's rulebook change when it's state law enforcement knocking on the door instead of a journalist or a private citizen?
If we connect this to the bigger picture,
Yeah.
a Tuffy request, which is named after an old Supreme Court case, is a specialized legal vehicle governing how a federal agency provides information, documents, or even employee testimony for use in separate litigation.
Okay, so it's strictly for legal proceedings.
Yes. When state law enforcement is running a criminal investigation, they don't use FOIA, they use TOPI.
Got it.
And the DOJ has its own specific set of internal published regulations for exactly how they're supposed to process, evaluate, and grant these requests to assist state litigation.
They literally have a published rulebook for exactly this scenario.
They do.
Which brings us back to the Administrative Procedure Act, the APA.
Precisely. The APA is essentially the ultimate rulebook for how federal agencies are allowed to behave.
Okay.
It dictates that an agency cannot just make decisions based on a whim or political pressure or personal annoyance. They have to follow their own written regulations.
So when New Mexico sues under the APA and calls the DOJ's denial arbitrary and capricious, how high is that bar in federal court? What mechanically do they have to prove to a judge?
Mechanically, the bar is exceptionally high.
I figured.
You cannot just go to a federal judge and say, the DOJ made a decision we disagree with, please overturn it.
That would be too easy.
Right. To prove a decision was arbitrary and capricious, New Mexico has to prove that the DOJ fundamentally ignored its own internal TOFI regulations.
They have to show they broke their own rules.
Yes. They have to show that the DOJ lacked any reasonable legal basis for the denial, that they failed to consider important aspects of the problem, or that they offered an explanation that runs completely counter to the evidence before them.
Wow.
They essentially have to prove the DOJ acted irrationally and broke its own rules just to keep New Mexico out of the files.
They have to prove the blockade is entirely manufactured.
Exactly.
And that second count really highlights the broader stakes of this lawsuit. It's not just about the paperwork, it's about the systemic damage being done. The lawsuit explicitly mentions the breaking down of critical trust relationships between the state and the federal government.
Because the entire American justice system, the day-to-day operations of catching criminals and prosecuting cases, relies on that informal cooperative trust.
It's the glue that holds it together.
It really is. If state and federal agencies begin viewing each other as hostile adversaries who have to sue each other just to share evidence, the system grinds to an absolute halt.
So let's pull back and synthesize what we've covered today, because this deep dive reveals something much larger than just the sordid, tragic history of the Epstein case and the 13,000 mentions of Zorro Ranch.
It goes way beyond that.
It really does. What we are witnessing is a fundamental stress test of the American justice system itself.
Truly.
You have a sovereign state asserting its clear constitutional right to investigate horrific crimes that occurred in its own backyard. And on the other side, you have the federal government utilizing its immense bureaucratic power, its protective orders, and its sheer institutional inertia to keep the vault firmly locked.
It's a profound clash of sovereigns, testing the very limits of dual jurisdiction.
It really is. It highlights the incredibly delicate tension between state sovereignty and federal authority, and it shows us exactly what happens when the traditional cooperative trust between those two levels of law enforcement entirely breaks down.
It's a dangerous precedent.
Yeah. When the feds tell the state to stand down, promise to share evidence, and then go completely dark, it doesn't just frustrate prosecutors. It leaves potential co-conspirators walking free, it leaves victims waiting for closure, and it leaves the public wondering who is actually serving justice and who is just guarding the vault.
And it really leaves you wondering about the long-term strategic implications of this 40-page lawsuit.
Oh, absolutely.
I mean, if New Mexico successfully uses the Administrative Procedure Act to pry open these heavily guarded federal files, will this become the new playbook for other states?
That's a huge question.
Could we soon see a wave of state attorneys general suing the DOJ to uncover federal secrets on everything from border enforcement to environmental probes, simply by alleging the federal government is being arbitrary and capricious in withholding evidence.
Just using the APA as a wedge.
Right. If a state's top prosecutor has to file a 40-page federal lawsuit just to get the federal government to share evidence on a universally condemned, multi-state criminal enterprise, what does that mean for the future of everyday law enforcement cooperation in America? If they can't agree to share notes on this, what can they agree on?
If this legal crowbar works here, the federal vault might never be secure from state intrusion again.
It's a fascinating legal horizon.
It really is something to watch out for. The playbook might be permanently rewritten.
Well, thank you for joining us on this deep dive. Keep questioning the information around you, keep looking at the mechanics behind the headlines, and we will see you next time.